Hello, Debbie.
Got 10 minutes. She'll call.
So I may be in the Zoom meeting.
Oh,
So will you just tell her what he said? And he's got, I think, 3 pros. I don't even know if he has, I think there's just one actually prove it. Well, there's, he has to hear one of them. It's a motion for new trial. And
Debbie, you're not muted right now.
Oh, sorry, Judge.
It's okay. Ms. Peoples, you are muted.
Sorry about that, Your Honor.
And Ms. Stallberg, you're muted.
Good afternoon, Judge.
And Ms. Sadler, you're muted, but you may intend that. So we are gathered here for a hearing on the petitioner, Ms. Telegina's request to be provided a reporter's record and clerk's record without cost. And I'm aware that the court reporter has filed perhaps as many as 3 challenges to the request. The opposing party has filed a challenge or objection. And I'm aware that there may be some procedural or format problems with both the reporter's challenge and the party's challenge. But by the provisions of Rule 145, I still believe it's my responsibility to require the declarant petitioner here to prove the inability to afford costs. That's found in Rule 145, paragraph E2, which says the court on its own may require the declarant to prove the inability to afford costs when evidence comes before the court that the declarant may be able to afford costs, or when an officer or professional must be appointed in the case. I'm unclear, frankly, about the meaning of that last clause.
May I have a word, Judge?
You certainly may, but not yet. I have received 2 filings this afternoon from Ms. Telegina. I've read them both. To the extent that Ms. Telegina is objecting to the hearing, I'll give you an opportunity to have your say. And I'm aware of the amended statement of inability to pay court costs. So with that said, is the respondent side ready to proceed? Ms. Peoples?
Yes, Your Honor, we are.
And Ms. Telegina, are you ready? Subject
No,
to your
Judge.
objection.
No, Judge, I actually joined this call. but
Just a
I'm not-
moment. Just a moment. I need to find out who else is participating in the hearing. Ms. Stallberg, what is your role here?
Judge, I'm here with the county attorney's office on behalf of Ms. Hernandez.
Very well. And is that Ms. Hernandez pictured with you?
Yes,
Okay, very well. Now, Ms. Telegina, you may proceed.
Judge, I joined this call, but I'm not making the appearance for the indigency hearing. I'm here only to raise my objection to this hearing moving forward, and also to ask the court to rule on my motion for free court record filed on January 6, 2023. I disagree to the indigency hearing moving forward because I didn't receive a mandatory 10 days notice. And absent such notice, I was not able to properly prepare for the evidentiary hearing. And because I bear the burden of proof in this hearing, it harms my ability to defend myself against contested instruments that have been filed by my opponents. And the mess which have been created with these 4 contested instruments filed by the court reporter and respondent, it's nearly impossible to sort through, but the fact is that none of these 4 documents meet 10 days notice requirement, which is mandated by Rule 145 F1 of Texas Rule of Civil Procedure. And none of these 4 documents meet sworn evidence requirement mandated by Rule 145 E1. I therefore move to strike these 4 instruments and objects to any hearing on this matter today. Alternatively, I move for continuance and request the court to provide 10 days notice to all parties who are on the call now in the open court and on the record. Judge, I can only add 2 cents that you said that you have read my objections to the hearing. There is a part there, legal briefing and cases, legal justification and cases. There is a myriad of cases holding that, and I quote, that shortening mandatory 10 days notice is improper, and that such 10 days notice must be filed in strict compliance with Rule 145, must be given in strict compliance with Rule 145. And given means not sending an email, but serving on the party and or announced in open court. So I cited all these cases in both my motion for free record filed on January 6, 2023, that I respectfully asking court to set for the hearing and rule upon. And also I cited applicable cases in my objections to hearing that I filed this morning, and that I also respectfully asking the court to take judicial notice of. So that's all, Judge. Again, I'm not here to proceed or participate in the hearing. I object to the hearing and respectfully request the court to give all parties 10 days notice as mandated by the rules.
So my recollection is that at one point I set a hearing for January 3rd, and you objected to a lack of 10 days notice about that. And I responded by setting the hearing that we're in right now for January the 10th. And notice for that was given to you, I believe, on December the 30th by email. So is your legal position that was insufficient notice?
Judge, my legal position is that my opponents were bombarding the court with several legal instruments contesting my affidavit. And none of these instruments, okay, I think that 2 of these instruments had no notice at all. And 2 of these instruments had less than 10 days notice. And because each instrument have been bringing some new assertions or allegations, the last, for example, let me give you an example. The Ms. Fernandez, the court reporter, filed, the most recent instrument that she has filed was filed on January 5th, I think. The title of the instrument is amended motion. This amended motion is the first sworn instrument she has filed. However, it doesn't have a notice at all. So again, there is a mess, and to sort up this mess, I think the proper way is to announce a 10 days notice in open court for everyone to be prepared and no one would complain. Also, because I filed amended statement of indigence with prima fide evidence, and which shows even bigger negative balance that I had on in November, probably makes sense to look into this document because it is more updated and because it contains prima fide evidence.
So is it correct that you received notice by email on December the 30th, 2022, that the hearing today, January 10th, 2023, was scheduled?
Judge, I received an email, but Rule 145 mandates that notice should be served, not sent by email. And I cited several cases in my objection to hearing, specifically explaining that the notice service of notice requirements is mandatory. It's not even, it's a clear language of the rule, and I can read it so let me just read what the rule says.
I'm aware of what the rule says.
Well, that's my legal position, that I was not served with the proper notice. Judge, and this is not, I respectfully, let me put it, I think that the court made all possible efforts to help us to set up this hearing. However, it was contentant's job to provide me with a decent notice as rule mandates. Because there was a series, I can only repeat my legal position, because there were a bunch of instruments, 4 of them, half of them, and each was bringing something new on the scene, but each instrument was defective.
So to be clear, I'm not sure I've gotten a direct response to my question.
Yes,
You did receive an email notice of today's hearing, yes or no?
I received an email, but my legal position that it is
No,
not
no,
served.
wait. For some reason, you are omitting a necessary clause. Did you or did you not receive an email on December the 30th noticing you of today's hearing?
Let me check, Judge.
The fact that you simply received some email does not answer the question.
I received an email on December 30th saying that Judge Delaney has moved the hearing in this case to January 10th.
Very well. Did it also say 4 o'clock?
Yes, it says 4 o'clock.
May I ask why you waited until January 9th to protest that there was insufficient notice of the hearing today?
I have not, Judge, waited. That was my first amended objections to the hearing. My first objections to the hearing were filed back in December, as soon as I received the first, I think, 2 or 3 instruments.
That was the objection. That was the objection to the January 3rd hearing.
Yes, Judge.
I'm referring now to the January 10th hearing.
I also raised my objection to, Judge, I cannot file objections every single day. I received several instruments, so I addressed them in my objections. So because like what I drafted my first amended objections, but then Ms. Fernandez filed something else. I'm sorry, then court reporter on January 3rd filed another contest. Then on January 5, she filed another contest. So there were like every 2 or 3 days, there were just another filing, and each filing was defective. So I had to amend my document, my objections, to address these issues as well. So I was keep updating my document. And as soon as I realized that there are only 3 days to the hearing, I filed the instrument. And actually, I objected also, I sent my objections also via email.
Mhm.
Judge, may I tell you something? Just historically, the last instrument that was filed, the instrument that contested my affidavit was filed on January 5, which is titled amended motion, and it was filed by court reporter. This instrument was the first sworn instrument, but it didn't have any notice. So I filed my motion for free court record, and part of this motion, the very next day, and part of this motion is objecting to today's hearing. Then I decided that probably you will not be able to take my motion, and I decided to make a separate filing today objecting to hearing. So in fact, to answer your question, in fact, I didn't wait till today or till yesterday. I filed my objections to today's hearing on January 6th. You should have a courtesy copy of this motion because it was filed on Friday.
Perhaps that's true. Let me direct everyone's attention to Rule 21A, Methods of Service. Paragraph 2 says, a document not filed electronically may be served in person, by mail, by commercial delivery service, by fax, by email, or by such other manner as the court in its discretion may direct. So tell me how the email notice of today's hearing was not legally sufficient.
Because, Judge, Rule 145 F1 specifically mandates the way how the notice should be provided. Let me quote it. The declarant must not be required to pay costs without an oral evidentiary hearing. The declarant must be given 10 days notice of the hearing.
Just a moment. I'm sorry. I have to.
Yes.
Sorry for the interruption. Go ahead.
Notice must either be in writing and served in accordance with Rule 21A or given in open court.
Do you believe an email is not one of the authorized methods in Rule 21A? And
I
think it goes without saying that an email is in writing.
There is a word served. I have not been served. An email is not service. That's my legal position, Judge. And also, as there is a case, one of the cases that I have cited this morning, it specifically addressed this situation. The Court of Appeals specifically addressed that email is not proper service with regards to Rule 145.
I'm sorry, which case is that?
Let me find it.
Query whether it predates some current amendments to Rule 21A, which specifically says that every notice required by these rules may be served by delivering a copy to the party to be served in the manner specified below. And one of the manners specified below is email. So point out your case.
I'm looking at the case, Judge.
Is it attached to your objections of hearing?
It's
On-
part of my objections to hearing, yes, legal justification and cases.
All right, point out the case that you have in mind. And tell me what, well, I guess the text of the case is not set out, right?
No, it is set up.
Some
I quoted
excerpt from the case is set out. What page of your document does that appear on?
Let me open it, Judge. Okay, legal justification.
What page?
It's page 7. But there are a bunch of cases here that I quote.
All right, which case?
I'm looking now at this case, Judge.
Ms. Womack, I have a question for you.
Yes, Judge.
For the record, I'm addressing Ms. Womack, W-O-M-A-C-K, the court coordinator. Was I correct in saying the first setting for the hearing on the indigency matter was January 3rd, or was that another date?
I'm not sure, Judge. It'll take me just a few minutes. I'm not sure when it was set first. I'm sorry, I have so many.
Right, I think it's probably academics. That's we're dealing with the notice that brought us to today's hearing.
Your Honor, if it matters, I do have that in front of me. It was January 3rd. Tuesday, January the 3rd.
All right, Ms. Telegina, what case law do you direct me to?
I'm looking at the cases, Judge. I'm sorry.
The two summaries that appear on page 7 both had to do with being given 10 days notice. I don't see any language declaring that email service is inadequate notice.
Judge, maybe it was the case that I'm not quoting here. I'm desperately trying to find this. Judge, I don't have this case in front of me, and I don't want to take any more of your time, but I'm pretty much sure that I have this case in my briefing.
So I overrule your objection.
My
To the
objection to what, Judge?
I'm trying to compose the sentence, if you'll be patient with me. I overrule your objection to the hearing going forward today. You have had more than 10 days notice that you would be required to establish your indigency at this hearing that is now in progress. So you may proceed to present evidence in support of your claim of indigency. If you decline to participate, of course, then I will have to rule that you've not established your indigence.
I raised my objection, Judge, and if there is a procedure established by Rule 145 for the Court of Appeals to review today's or the order, so I objected to proceeding to this hearing. I raised my objection that I didn't receive a proper notice. I have no way out because you decided to move forward with the hearing. I was not able to properly prepare, but I have no way out but to participate in this hearing despite my objections that I didn't receive a proper notice. So
I didn't understand the first few words of your statement just now. Did you say something about waiving objections?
no, Judge, I'm not waiving any objections. I'm saying that despite my objections, I have no way out but to proceed to participate in this hearing.
Very well, understood. I'm ready to receive your evidence then. Do you wish to be sworn as a witness? If you'll present testimony, I'm afraid you must be sworn.
Yes, Judge. I'm calling myself as a witness.
Do you swear that the testimony you'll give in the proceeding before the court today will be the whole truth, so help you God?
Yes, Judge.
Very well, you may proceed.
So I'm requesting the court to take judicial notice of my First Amendment amended First amended statement of inability to afford payment of court cost for an appeal bond that I filed this morning. My name is Tatiana Telegina. I was born.
Just one moment. You've asked me to take judicial notice of something, and I have it on the screen before me now. That is your pleading filed this morning, January 10th at 10:15 a.m., entitled Notice of Filing First Amended Statement of Inability to Afford Payment of Court Costs and Appeal Bond.
Yes, Judge.
So
Attached
in
to this
response to the request that I take judicial notice of this document, what says the respondent counsel, Ms. Peoples?
Judge,
Your Honor.
attached to this notice, there is first amended statement of inability to afford payment of court costs or an appeal bonds. And that's why, and that is the document I'm requesting you to take judicial notice of.
I understand. Ms. Peoples, your response.
Thank you, Judge. Yes, Your Honor, this notice of filing of amended statement was just filed by Ms. Telegina today. I don't believe it was timely filed for the hearing and providing us adequate time to review. However, after review, it's still our objection to her original affidavit. All of our objections still stand. Ms. Telegina has still not provided prima facie evidence required under Rule 145F that she would qualify for a waiver of the costs or services or to have a professional appointed in this case.
The question is whether I should, quote, take judicial notice, unquote, of the document, analogous to admitting it into evidence.
Well, I would object to it being admitted into evidence. I do think that the court can take notice of its file and what has been filed, but I don't believe that that allows it to become evidence in the case unless correctly and properly proffered by Ms. Telegina.
I agree. I take judicial notice that the document has been filed, but I don't consider the contents of the document as evidence. That will have to be produced independently. Now you can proceed, Ms. Telegina.
My name is Tatiana Telegina. I was born on September 17th, 1967. I reside in the Woodlands, 2000 Hughes Landing, apartment 104, Texas. I declare under penalty of perjury that I'm unable to pay court costs and court bonds because according to my affidavit of, according to my first amended statement of inability to afford payment.
Your Honor, I would object to Ms. Ms. Telegina testifying from her affidavit that's not in evidence.
I overrule. Go on.
According to my first amended statement of inability to afford payment of court costs or an appeal bond, the negative balance as of today is, and now my total debts as of today, and with total debts, I mean unpaid bills, are $865,457.11. This amount is stipulated in my affidavit in the line total debt unpaid bills. I have following assets as of today. I have cash of $1,048. I have in Raiffeisen Bank in Russia I have an amount of Russian rubles, which approximately amounts to $31.30. I have at my Wells Fargo checking account $5.12. I have at my Wells Fargo investment account stocks that as of today are the value of the stock, monetary value is $200.25. And I have jewelry, which of approximate value of $700. So total value of the property that I possess in US is $1,984.67. My monthly expenses I am requesting the court to take into evidence documents that are supporting my statement of my assets, of the value of my assets.
Welcome to the Odyssey Navigator.
So I would like to introduce into evidence the statement from Raiffeisen Bank showing the balance of my checking account of $5.12 as of today. And the statement of my Raiffeisen Bank account as showing the balance of approximately $31, because the exchange rate varies, as of November 21, 2022.
All right, so I must deal with the offer of the bank statement into evidence. So the record is clear. The first document you've offered into evidence is the bank statement from what institution?
From Wells Fargo Bank. The statement as of today, January 10th, showing the balance of my checking account.
So is this a document that you have attached to the pleading you filed this morning?
This document is attached to my affidavit, to my First Amendment statement of inability to afford payment of court costs or an appeal bonds.
All right, so what says your side, Ms. Peoples?
We object, Your Honor. This document is hearsay. It hasn't been provided as a proper exhibit also prior to this hearing. It hasn't been authenticated, so we would object to this coming in across the board. It also appears to be altered. It has markings on it from what I can tell, and therefore it's not an original document either.
Okay, Ms. Telegina, if I'm to enforce the rules of evidence, I have no choice but to exclude that exhibit, but you're perfectly welcome to testify from your knowledge what amount of money you have in that account.
As I already testified, Judge, according to the statement from Wells Fargo, as of today, the document is—
Objection, Your Honor, to her referencing the document, the statement that was not been admitted as hearsay.
I'm afraid I have to sustain. Is it your belief that you have a certain amount of money in that account? If so, tell me what your belief is.
As of today, the balance of my everyday checking account in Wells Fargo is $5.12.
Very well. Now we're going to have the same problem, I suspect, with every other statement you've attached to your affidavit. So it might save us all some time if you just enumerated your accounts and told us under oath how much money you believe you have on deposit there.
Judge, I would like to introduce into evidence my first amended statement of inability to afford payment of court costs or an appeal bonds for the time being without exhibits.
Ms. Peebles?
Your Honor, sorry if I may pull that up. I clicked off of it on accident. Without exhibits, I don't have an objection to her sworn statement without the exhibits attached to it.
So, Ms. Stolberg, I deem the court reporter to be a party to this hearing today. So you are welcome to participate as counsel. Do you have any objections?
I don't have an objection to the affidavit itself, except for she does reference, except for the extent it references attachments that aren't coming in. But to the rest of it, I don't have an objection.
I couldn't understand you.
I don't have an objection to the affidavit itself coming in. Can you hear me?
Yes,
Okay.
but if it comes in, every statement in that affidavit is going to be evidence before you.
Right. As long as the attachments aren't coming in with it.
All right. So in the event there's an appeal from the outcome of today's hearing, Ms. Mendoza, I've admitted as petitioner's exhibit 1, her affidavit excluding the attachments. Is that clear?
Yes, Judge.
My first amended statement of inability to afford payment of court costs or an appeal bonds as of today. That's the document I was requesting to admit into evidence.
So that would include the affidavit that we've been discussing, correct?
That is the affidavit. So this statement is a sworn affidavit.
Very well. I understand. It's admitted.
Thank you, Judge. So as I already testified, according to this statement and to my best knowledge and the documents that I have, the total value of
Objection, Your Honor, again, as to the reference to documents that are not into evidence. She can testify as to her knowledge of those accounts as she's done in her sworn statement, but referencing other documents is inappropriate.
Judge, I was referencing the statement itself, which
Very well.
provides on the first page, it provides, on the second page, it provides the list of my assets. So I was referencing to my statement.
I overrule the objection. Go on.
My monthly expenses, so with total value of property in US being $1,984.67, I have my monthly expenses of rent of $2,051, food and household supplies $300, utilities and telephone $260, clothing and laundry $50, medical and dental expenses $50, insurance as of February 1st, $1.81, transportation, which is actually Uber because I don't have any car, is $100 a month approximately. And my monthly credit card payments, approximate amount of my monthly credit card interest payments is $1,487. So my total monthly expenses amount to approximately $4,299.81. The total unpaid debts as of today constitute $865,457.11. My debts include the $827,518.50 that I should pay as per court order of 23rd of August 2022. I have unpaid lawyers billed to my Russian attorneys who represented me in Russian courts of $13,473.90. I have an unpaid bill to the prayer law office of $2,081.64. I have other unpaid bills. I have unpaid rent, which I should have paid on January the 1st. Because of the interest now, but I'm defaulted on my rent payment. I was not able to pay my rent. So with interest, my default payment is the payment that I owe to the property is $2,237.38. I was not able to timely pay my electricity bill, and I owe to the electric company as of today $99.43. I was not able to pay my 3 insurance installments, so I owe to insurance company as of today $8.26. I was not able to timely pay my internet bill, and as of today, I'm in default of payment of $100.52. I have 7 unpaid credit card debts, and so I owe to Chase Bank on my card number 690 $10,407.86. I was not able to pay timely the interest on this credit card. I owe to Chase Bank on my credit card 6386 $551.87. I was not able to timely pay this credit card bill. I owe to Wells Fargo, American Express 9132. 4 last digits of this card is 9132. I owe $2,425.18. I owe to Amazon credit card 4 digits 6166. I owe $2,116.85. The limit of this credit card is $2,000, so I over the credit limits for $160 $16.85, and I was not able to timely pay the interest on this card. I owe to PayPal a card account, 4 last digits of the account is 9657. I owe to PayPal $1,892.84. I was not able to timely pay the interest on this debt. I'm not sure which card is this. Just a second. I owe to Capital One Walmart card $283.42. This payment was due today. The payment on this credit card was due today. It's $65, and I was not able to make it. There is also Macy's credit card. And I owe to Macy's $244.71. I was not able to timely pay interest on the card with 4 last digits 4656 as well. And also on my checking Chase account, there is a negative balance of $15.82. Also, I received on January 6, 2023, I received a notice from Telegina, my electricity company, a notice that my bill is overdue and that my payment is due immediately, but I was not able to pay it. The payment was $99.43. I received a late notice from my property where I rent the apartment on several notices. The most recent on January 5th, I received a second late notice that I have immediately pay $2,237.38, but I was not able to do that. I received several reminders from my insurance company that I had since 2017, Blue Cross Blue Shield of Texas. I received a notice that I should immediately, that the amount due to them is $2,008.26, but I was not able to pay it. I received on December 20th, I received an immediate action needed notice from Chase Bank regarding my card ending 6980, that I should immediately pay the balance of $555. On the same date, I received notice from Chase Bank regarding my another card that I should immediately pay the balance due, but I was not able to do so. I received a notice from Macy's that I should pay my credit card interest, but I was not able to do so. The minimum payment, as I already testified, the minimum payment was $66. I was not able to pay it. Now, I tried to find a job. In the interest of the judicial economy, I attached to my affidavit several emails denial my job applications. But in fact, I applied to at least 100. I made for the last September, October, November, December of 2022. I made at least 150 applications for different open positions for the Corps for different roles. Different companies all of them were denied. I'm still trying to find a job so I would be able to pay my bills. But for the moment, despite the fact that I was I have some colleagues, formal colleagues who tried to reference me to
Objection, Your Honor, to hearsay.
there is no, I haven't even, there is no hearsay. I haven't even finalized my statement. So what your objection, what is the objection, Judge? I didn't understand. Specifically, what my phrase is the objection?
Ms. Peoples?
She referenced her colleagues who made references, and at that point it sounded that she could only be testifying about something that her colleagues had told her, which is hearsay.
Your Honor, I was not planning to testify about who told what. I am testifying who did what.
Proceed. Objections overruled for now.
Several colleagues tried to help me to find a job. Formal colleagues tried to help me to find a job. I was referenced to Google, for example, but I received, but my application from Google was denied on December 12, 2022. My another application for job in Google was denied on January 10th, 2023. My another application to Google was denied on December 12, 2022. For example, my application to
Judge, I'm gonna have to object if she's testifying based on a document. Hearsay.
Let me hear what she has to say, and I'll rule on
It just,
admissibility.
it just appears that she's reading from a document.
I am reading from a document because I don't have memory to recall all 150 applications that I have made. So I'm looking to the document, but I haven't made an effort to introduce this document into evidence. So the fact that I'm reading, what is the problem with me reading from the document, Judge?
I overrule the objection. Go on.
So my application to Confluent was denied on September 1st, 2022.
Tell us again the employer.
Confluent, C-O-N-F-L-U-E-N-T, Confluent. My application to Coursera was denied on October 10, 2022. My application to Deal Hiring was denied on November 24, 2022. My application to Hitachi Solutions was denied on October 18, 2022. My application to Mary Shinash Smith was denied on November 10, 2022. My application to Kelsey Lamb was denied on November 3, 2022. My application to WordPress was denied on October 24, 2022. Apart from these applications, I've made made nearly 150 more. I literally was applying to every job that I was at least that I have competency to. And but because I have never worked in US, my last employment was in Europe. And because I was representing myself in this litigation, so I was not able to work and represent myself in this litigation of which started in 2017. For American employers, I don't have experience in here in US, job experience. Therefore, and because I have never been employed here in US, I'm not eligible for a
Objection, hearsay, and speculation, Judge.
Overruled. Go on.
So I've made at least 150 attempts to apply for different roles, and I made it through several interviews, but all my applications were denied so far. But
Just a moment. I overruled the objection to the testimony you're about to give about not being eligible for something. And so that means you're free to give that testimony.
thank you, Judge. Actually, I received informal feedback from several recruiters saying that
Your Honor, I would
because
object to hearsay.
I'll have to hear it and consider the objection. Continue your statement.
I received an informal feedback from several recruiters stating that because I don't have experience, job experience of here in US, and because of my age, I'm 55 years old, I'm not a candidate that they are looking for.
Okay, I have to sustain the objection. I'll disregard.
So that is, I don't see in the nearest future possibility to get a job. So I don't see how I will be able to. I keep applying very actively every day, nearly every day, when I'm not working on any documents for this litigation. I'm applying, I'm trying to find a job, but for the moment, as of today, I don't have any job offers or I don't see any opportunity for me to get a job in the nearest future. Now, I have applied for state benefits. I specifically, and one of my applications was approved. I'm receiving a premium tax credit of $783 a month from insurance marketplace. My application ID is 478 4725 256, and it was approved on January 9, 2023. And I followed the procedure of marketplace insurance eligibility. And now, as of I'm enrolled to insurance that will cost me $1.81. And before I was paying nearly $700 a month. So I'm insured now by Aetna, CVC Health, and my payment is $1.81 a month. I also applied to Texas benefits, the SNAP food benefits. My application was made on January 4th, and it is now under consideration. So it has not been, the decision has not been made yet. I also applied for a program, for a Texas program that is called rent relief. However, the Texas rent relief program has been closed, and my application was not has not been processed because they are not accepting any application. The portal, the application portal is closed, and they are not even putting, they haven't even been able to put me on the waiting list because they don't have finances. They are not putting anyone on the waiting list. I also tried to receive a legal support. So I applied to several I applied already, and I keep applying to free legal aid. So I would be able to have someone represent me at the appeal stage, but I was not able to get such support because so I applied to Lone Star Legal Aid. They denied my application, stating that they
Objection,
cannot
hearsay.
provide legal. Excuse me?
I'll hear her out and make a ruling. Finish your
In
statement.
response to my application, I received a response that Lone Star Legal Aid cannot provide legal assistance in my divorce matter, and I requested legal aid in the matter of appeal and in the today's hearing.
Hang on.
So my application was denied, and it is stated, in response that I received from them, stated that Lone Star Legal Aid cannot provide legal assistance in this matter. And I requested legal assistance in the matter of appeal of my divorce case.
Okay. Who lodged the objection? Is that you, Ms.?
That was mine. We'll withdraw it. She cleaned it up differently. That's fine.
Very well. I overrule the objection. Go on.
I also applied to free legal aid and nonprofit, to several free legal aid and nonprofit organizations. None of them, however, provide legal support in appeal of the divorce cases. So I was not able so far to receive a free legal support, so I would be able to have a legal professional handling my appeal, so I would be able to focus on my job search. I also applied to Legal Aid Now organization. I received a response from them yesterday, actually, on January 9, 2023, stating that someone from their organization will contact me when practically possible. But so far, despite all my efforts, I was not able to obtain a legal support from a free legal support. I also talked to several lawyers asking if they will be able to take this case pro bono, but regretfully,
I would object, Your Honor, to the hearsay and relevance.
I'm not sure it is relevant, Ms. Telegina. We're here to
it's
decide on your,
relevant because, Judge, I'm trying to, because I filed a notice of appeal. But at the same time, which takes a lot of time and efforts to prepare. But at the same time, I need to focus on finding a job to pay my everyday bills. So that's why I'm referring to my multiple efforts to find legal representation, so I would be able to focus on my job search.
okay, I overrule the objection. Go on.
So as I testified, I asked legal aid providers, several legal aid providers to represent me, but none of them would take my case. And I'm not represented by legal aid, but I continue looking for legal aid. I do receive public benefits now, which is health insurance marketplace benefits of $783 a month. And as I testified, I applied for tax SNAP food benefits, but they haven't processed my application yet. I don't have any income. Apart from that, I have zero in my monthly wages. I'm unemployed from January 2008. I receive other than health insurance marketplace tax benefits, I receive nothing in public benefits yet. I don't have any other people in my household, so I don't receive any income from them. I don't receive any retirement pension. In fact, I'm not eligible to retirement pension here in US. I don't receive any payment from Social Security. I don't receive any disability or workers' compensation or military housing or any royalties. So I don't have any income whatsoever. That's all, Judge, that time was planning to testify today.
All right, we've been going for about an hour and 20 minutes. I need to give the reporter a break. We'll stand in recess for 10 minutes, and then we're going to continue. Unfortunately for everyone, we have to complete this tonight because I start trial tomorrow for 2 weeks.
So sorry, Judge, just to confirm, you said 10 minutes?
I did.
Thank you.
Ms. Sadler, I cut off your video by mistake.
No problem, Judge. I'm sure you can cut it back on.
Your Honor, just as a matter of housekeeping, Ms. Sadler is not able to turn back on her video and asked if you could please assist with that on your end if possible. Thank you, Judge.
Ms. Telegina, are you with us?
Yes, sir.
Okay. So I'm not unaware of the fact that it's 5:30 in the afternoon and some of you on this hearing may have childcare or other responsibilities after hours. If you've not been able to make arrangements to take care of those matters and you're in some difficult situation as a result, let me know now. All right. I take it everybody's been able to plan around that. I apologize for the lateness of the hour and the hours to come, but I'm anxious to conclude this matter one way or the other.
Your Honor, I actually want to add something to my testimony. May I do so now?
You may.
Thank you. In my previous inventory that I filed with this court, I think my first inventory I filed with this court on May 2018, and then I filed several others inventories while we were progressing with discovery. I was amending my inventories. So in my several inventories, I stated that I have 2 properties in Russia, and to my best recollection, I stated that I haven't been on first property for 20 years, and I haven't used another property for 15 years. I haven't been to Russia since May 2016. I cannot go there now because I don't have money to buy a ticket. In addition, 11 months ago, in February 2022, Russia invaded Ukraine, and Russia is now at war with Ukraine. And it is not safe to go to Russia now because the country is literally in war, at war. So even if I had money for a ticket, I have no documents for these 2 properties whatsoever. I haven't been able to pay any taxes on this property. I don't have any certificate confirming or any other documents confirming my rights to this property. As I said, I haven't even seen one of the properties for, I think for at least for 20 years, maybe more. So the only document that I had was a membership book in a garden cooperative, that I'm a member of this cooperative, but this document of garden cooperative where one of the property is located. But this document doesn't confirm the my entitlement to the property. It's just a community membership. And because I haven't paid the membership dues for at least 6 years, I don't know if I'm even a member of this gardening community any longer. In any case, I have neither access to these 2 properties nor any documents that certify or somehow prove my rights to this property. I don't know even if I have right to this property because I haven't been paying and any taxes for so many years. Maybe this property is confiscated.
Objection, Your Honor, speculation.
Overrule.
Are also I don't have money to hire someone who would be able to investigate the situation with this 1.5 properties actually, because one is a tiny house the last time I see it, on a tiny piece of land, and another was a part of the house with several neighbors. Also very small, one room and a porch, which was constructed before World War II, so beginning of last century. So that's why, even if I had if I don't have money to hire someone in Russia who would be able to make some research and get documents on this property. And that's why I actually stated in my inventories that both properties are of negligent value, because I don't know what is the value of this property. I haven't seen it. I don't have any document justifying my eligibility to this property. But also, as I already testified today, I owe money to Russian lawyers.
Objection, Your Honor, cumulative at this point.
Excuse me?
I'm objecting to cumulative, Your Honor. I'm sorry. I wasn't sure if you could hear me.
You've testified about the money you owe to Russian lawyers.
Yes.
So go on.
I testified today that I own more than $13,000 to Russian lawyers. So even if I had documents justifying my eligibility to this property, they would probably be the one who would try to put their hands on this property. Anyway, I just wanted to testify that I didn't put these two pieces of property that I once had in my statement among of my assets, because I don't have any documents to justifying my rights to this property. I don't have access to this property for 15 and 20 years. I don't know if it even exists, and even if I can do something with this property, but practically I can do nothing to this property because I was not paying taxes, because I don't have any documents, and because this property is located in Russia. That's just, Judge, that's the only thing that I wanted to add to my testimony.
Okay, Ms. Peoples and then Ms. Dahlberg.
Thank you, Your Honor. Ms. Telegina, you mentioned the various applications at companies that you applied for. Did you apply at companies like Target, for example? Did you apply at Target?
What is Target?
The retail store, Target.
No, but I don't have any.
Objection, Your Honor, non-responsive after no.
No, I haven't applied to Target. I do not have any retail experience.
Ms. Telegina, isn't it true that you did not apply at fast food restaurants in order to gain any kind of employment?
Actually, I have.
But you didn't testify to those places that you
I testified that I have applied, that I have made more than 150 applications, and I testified, I provided several examples, but I applied to Macy's, for example, or to several restaurants in the neighborhood. but all my applications were denied. And actually, I tried.
Objection, Your Honor, non-responsive.
Okay, I'll sustain. Next question.
Ms. Telegina, did you take the opportunity to apply to any other, I would say, entry-level positions that you wouldn't need experience to get hired at?
Yes, ma'am.
And what
Yes.
locations were those?
Yes, let me just give you one. Only yesterday, I received, just to give you facts. Okay, now, only yesterday at 1:22 p.m., I received another denial of my application. I applied to work as an executive assistant to in a company which is DLZP Group, and they denied my application after interview. Actually, we had an interview, a second interview scheduled for tomorrow, but out of sudden I received the denial, the cancellation, and an email from human resource assistant and recruiter.
Objection, Your Honor, non-responsive and hearsay at this point.
I'm stating that I applied for junior positions like executive assistant and secretary, and even this application was denied most recently yesterday.
Okay, next question.
Ms. Telegina, the expenses, the monthly expenses you have listed on your sworn affidavit, the rent, the groceries, your cell phone, let's take those one by one. If you're not working, where are you getting the financial assistance to pay for your $2,000 a month rent every month?
I had savings, but as I already testified today, my savings are close to 1,000, a little bit like. Let me open the document.
Ms. Telegina, is it not true that in 2017, you received the sum of $100,000 from Vladimir Nechayev as part of the divorce settlement?
Yes, ma'am. And nearly all this
And
amount I paid.
Objection, Your Honor, non-responsive.
You'll have an opportunity, Ms. Telegina. I sustain. Go on.
And Ms. Telegina, you received the sum of $60,000 from Vladimir Nechayev in 2018, correct?
Yes, ma'am.
And you received the sum of $60,000 from Vladimir Nechayev in one payment in 2019, correct?
Yes.
You received the sum of $60,000 from Vladimir Nechayev in 2021, correct?
Yes.
And you received the sum of $60,000 from Vladimir Nechayev last year in the year 2022, correct?
Yes.
And that's a total of $340,000 that you had at your disposal from 2017 through 2022, not counting any income employment, correct?
Yes.
And in addition to that, you do have the two properties in Russia, although I know you can't speak to their value at this point. Is that right?
I don't know. I testified that I don't know if I have this property any longer.
It's been invited. Go ahead and finish your answer. Ms. Telegina, you can finish your answer about the Russian real estate.
I testified that I don't know if I own this property any longer, if this property were not confiscated from me, but I don't have any documents justifying or proving my eligibility to these properties.
Okay,
And
I've heard enough. I've heard enough for now. I may have some more questions about that. Ms. Peoples, go ahead.
Thank you. And Ms. Telegina, you also don't have any documents to justify that you don't still have interest in those properties, correct?
I don't understand the question.
Okay. You testified that you don't have any documents to prove whether you have any interest in those properties.
No,
The
I don't
same
have any
can
interest
also
in
be
these
set-
properties.
Objection,
Wait.
Your Honor.
One at a time.
I can testify now that I don't have, okay. Yona, may I ask counsel to clarify the question, because it's, English is not my first language. What does it mean, interest? I'm not renting this property. I haven't seen this property for 20 and 15 years. I don't have access to the property, so I can testify now that I'm not getting even $1 from these properties for at least $20 for 20 years now. I don't have access to these properties.
Her question to you was, as you have no documentation showing that you still own the property, she
Yes.
wants to know if you have documentation showing that you do not own the property.
No, I don't have any documents that I don't, that I not own the property.
Ms. Telegina, you represented during the underlying case that you had $10,000 to $15,000 worth of separate property jewelry that you claimed, correct?
No, I'm not sure about that. What are you referring to?
I'm referring to your sworn statements in an inventory in the underlying court under your separate property that you listed jewelry, $10,000 to $15,000.
Judge,
separate
I
property.
object because Miss Peoples are now referring to something that is not in evidence.
Overruled. It's a fair question. Please answer.
Can I please hear this question again?
Sure. Did you list in an inventory, a sworn inventory that you filed with the court, did you list separate property of jewelry pieces that cost a few jewelry pieces that cost $15,000?
I don't recall, Judge, but this is very possibly because the counsel is not referring to any particular document or to any particular inventory that I allegedly filed, but this is very possible. However, because I had a lot of expenses, because I had a separate court litigation in Russia, which started, I think, 3 years from now. So I had this litigation in Russian court. So when I went to Greece into 2018, I took this two pieces of jewelry with me, and I gave it to my sister so she would be able to sell them to pay the local Russian lawyers' bills. So whatever I had, it is sold, and it was the money that it was sold back, I think, in between 2018 and 2020. So at least 2 years from now, in order to pay the bills lawyers' bills that I had in Russia, because I had no money or any income in Russia. And I very much, so the only jewelry that I have is the one that my husband, Vladimir Nichayu, gave me in 10 years of marriage, is a tiny thing from Tiffany that the purchase price was approximately $700. So I don't know how much it costs now, if I will be able to sell this.
Okay.
Now,
Hang on.
What I have.
Stop, please. Stop, please. Next question.
Ms. Telegina, with your amended affidavit, you represent that you have been approved for a benefit that you state provides prima facie evidence of your inability to afford costs in this case. Is that correct?
Can you repeat your question, please?
You testified that the health insurance marketplace benefit under Texas Rule of Civil Procedure 145, provides evidence to the court of your inability to pay costs in this case. Is that correct?
Ms. Peoples, can you please rephrase the question, because I don't understand what is the question? Can you please make it simpler for me to understand?
I'll do my best, Ms. Telegina. You testified that you are receiving some type of government benefit through healthcare marketplace, correct?
Yes.
And you believe that that presents evidence to the court of your inability to pay costs in this case, correct?
Let me open the document.
Your Honor, I would object to her referring to anything while she's testifying and referring to a document.
It's
I'm
a
simply
document.
asking about her testimony.
It's a document that's in evidence, Ms. Peoples.
Her affidavit, yes, not the underlying documents. So I would just make clear that I'm objecting to her referencing anything that's not in evidence.
I objection, Judge, because this particular information is clearly stipulated in my affidavit. So I'm referring to the affidavit, and that is exactly the document that I'm trying to open now. Okay, on the first page of my affidavit, to the question, do you receive public benefits? I stipulated that I receive health insurance marketplace benefits of $783 a month. I haven't received it because the application was approved only yesterday. But
Objection non-responsive.
I sustain. Next question.
Ms. Telegina, is it not true that this benefit is simply a tax credit for cost sharing of insurance and not a monthly benefit that the state or any government assistance program is going to send you?
Ms. Peoples, what I understand is that health insurance marketplace, this is my understanding, is a government or finance organization which actually—
Objection non-responsive.
Okay, look. I am tiring quickly of game playing here. The question is very simple. And the answer should likewise be very simple. Do you contemplate getting cash each month to dispose of as you see fit as a result of this benefit? Or is it simply applied against an insurance premium that you would otherwise pay without it coming into your possession?
Exactly, Judge. So that is a simple question.
No, wait.
I understand.
Just wait.
Yes.
I offered
And I
two
can
alternatives.
provide a simple answer to this question. Yes.
Which is it, Ms. Telegina?
I haven't, again, my application was approved only yesterday, but how I understand, I don't need now to pay nearly $700 premium for my insurance, because my insurance company, Ayetna, is getting this money from the government source directly. I am paying only $1.81 per month.
Got it. Now, again, Ms. Peoples, next question.
Thank you, Judge. Ms. Telegina,
No, but hang on just a minute. I don't want this hearing prolonged by unnecessary word jousting. So, Ms. Telegina, I want a concise answer to the question. I don't want you to ramble off about about government benefits, just a simple answer to the question will suffice.
Yona, when
No,
you are
no,
asking
no,
me the question, it is
no.
simple.
No, the question from the lawyer was equally simple. And then you started talking about government benefits. So just try to answer the question. If you don't understand the question, or if it's confusing to you in some way, appeal to me and I'll fix it.
Okay, thank you, Judge. Will do.
Right. Now, Ms. Peoples, continue.
Thank you. Ms. Telegina, you haven't currently been accepted to be represented by an attorney providing legal services to you through the Texas Access to Justice Foundation, have you?
Can you repeat the question, please?
Yes, you are not currently represented, nor have you been approved to be represented by an attorney providing legal services to you through the Texas Access to Justice Foundation.
No, I haven't. I haven't been approved. I applied, but I haven't been approved.
Ms. Telegina, you have not been approved to be represented by a provider funded by the Legal Services Corporation, correct?
I haven't heard. I don't know what you're referring to. I don't have an answer to this question.
Ms. Telegina, you are not being represented, nor have you been approved to be represented by a nonprofit that provides legal services to persons living at or below 200% below the federal poverty guidelines, have you?
Judge, I cannot answer this question because this question actually contains several. Can we break it into several questions? Because in one question there are like several. I cannot answer simple yes and no to this question.
I'm happy to rephrase. Ms. Telegina, you are not being represented by any nonprofit, correct?
Yes.
Yes, you are being represented, or no, you're not being
No, I already testified that I'm not being able to receive a
And Ms. Telegina,
free legal aid.
And you have not applied for free legal services and were found to be financially eligible, but declined representation, correct?
No.
Your Honor, I'll pass the witness.
Judge, I would like to correct my answer before. I was, so the answer to your question is no, because no one from these providers have even asked the question of my income. We didn't get to this stage. So I cannot affirmatively say that my application was denied because
Objection non-responsive.
I was not even asked the question.
Your Honor, I would object to the witness continuing to
Let's all
respond.
object. Let's all object. So Ms. Peoples has passed the witness, and I'm going to defer now to Ms. Stahlberg. Questions that you may have, ma'am.
Ma'am, are you on receiving Medicaid?
No, I was not approved by Medicaid yet.
Okay. Are you receiving any food stamps currently?
I testified that I applied.
Objection non-responsive.
It's a yes or it's a
My
Hello?
application has not been processed yet.
okay.
Ma'am, are you receiving food stamps currently?
I'm not receiving food stamps.
Okay. And you're aware that you filed sworn inventory statements with this court during the divorce process in 2018 and 2020, correct?
Yes.
Do you remember telling the court about all of your bank accounts and all of the assets and liabilities that you and your husband had?
Yes.
Okay. Do you remember on April the 25th, 2018, it's attached to the supplemental motion filed by the court reporter in this case. Do you remember that petitioner's sworn inventory that you filed?
No, I don't remember, but let's try to refresh my memory.
Okay, if you can look at the supplemental motion in support to contest the affidavit of inability to pay filed on January 5th. The first page is the motion. The third page in starts petitioner sworn inventory.
Judge, I object reference to the document that is not in evidence.
I'm
Overruled.
asking you, do you recall filing an inventory in 2018?
I already testified. I recall filing, yes.
Okay, and Judge, I'd move for admission of Court Reporters Exhibit 1. It is petitioner sworn inventory. It was filed in this case in this court on April the 25th, 2018. It is a statement of the party opponent. It is a statement made under oath by Ms. Telegina.
No objection, Judge, from a respondent.
Can I look at the document, Judge, first? Can you please refer once again, what is the document?
It was filed in this case on April the 25th, 2018. It is petitioner's sworn inventory. It is attached to the supplemental motion that was filed on January 5th, 2023.
So you are now trying to introduce into evidence the document that is attached to the motion that your client have filed. Is that right?
I am trying to introduce evidence of your sworn inventory that you swore was the case in 2018. It is
Are-
also attached as an exhibit to the motion.
How do I know that this is the document that I have filed?
You have an opportunity to examine it now.
Yes.
Someone help me locate it among my email. In other words, when was it transmitted to me?
It was e-filed on January 5th, 2023 at 3:50 p.m. So it should be in your emails sometime around that time.
I'm afraid
I'm not sure.
I'm afraid I only get those materials that are e-filed by Ms. Womack transmitting them to me. Tell me again the filing date.
January 5th, 2023, 3:50 p.m. It's called supplemental motion in support of contest to the affidavit of inability to pay.
So, Ms. Womack, can you tell me when you sent that to me?
Ms. Stauber, could you tell me again the date, January 5th?
Yes, Haley's supplemental motion, Haley Hernandez's supplemental motion that she filed, it's an exhibit. It's a second exhibit on that motion.
Yes, Judge, I emailed it to you on Monday the 9th. It was attached, it's supplemental motion contest of affidavit of inability to pay. Also was attached was petitioner's motion for free court record. January the 9th at 10:17 a.m.
I'm loading the Hernandez document now.
Judge, while you're locating that, I just wanted to let you know that here at our office, they just announced over the loudspeaker that they're going to be conducting a test of the alarm system. So I apologize in advance if that goes off, and we'll try to quickly mute.
Okay. So I have found the document attached to Ms. Hernandez. Filing. It is Exhibit 2, and it shows in the upper right-hand corner that it was received and e-filed for record April 25th, 2018 by the Montgomery County District Clerk. It seems to bear the signature of Miss Telegina, with which I'm familiar now.
Judge, may I ask you, what document are you referring to when saying that this is my signature?
The sworn inventory,
Which one?
the one filed April 25th, 2018 in this court.
I don't see my signature here on this document.
It's at the top of page 2 of that document. That's your signature, and then it's notarized.
In my document, there is no signature, but let's assume that that is the document.
Wait a
I
minute.
don't recognize this document, but
Wait,
let's
I'm
assume-
sorry. Wait,
Yes, Judge.
are you looking at the
Yes.
same
Would you-
document I'm looking at, which
Would it
is
help if
the
I shared
attachment
screen?
to?
That's why I have doubts that we are looking at the same document, because I'm looking at my petitioner response and objections to hearing. But let me try to locate the motion that Ms. Fernandez filed.
Judge, would it help if I shared the screen?
It might.
No. I think I'm going through another source.
Can I
My
clarify? I'm
motion-
also looking at the same thing. It's the January 5th, Ms. Hernandez's supplemental motion to contest the affidavit.
Yes.
And this particular exhibit starts on page 17 out of 24. I'm sorry, 16 out of 24. Is that the correct document? I'm just making sure. I
No,
have it.
it's, so the supplemental motion, and then it has an exhibit 1 that's 2
Mhm.
pages, and then it starts with exhibit 2. So it's 1, 2, 3, it's page 4 of the motion essentially.
Perfect. Thank you. I think I was looking at the wrong one.
And the top right hand side, it says received and e-filed 4/25/2018 at 4:43 p.m.
Now, how long is this sworn inventory document? How many pages?
1, 2, 8. It is 5 pages total, Judge, including it starts petitioner sworn inventory. That's 2 pages. There's a certificate of service, and then the inventory itself is 2 pages.
Of that document, it spans page 4 through 8. Is that correct? Out of 24.
Maybe right. So yeah, 4 through 8 of, 24, because it's showing 25 on Odyssey, because that has a
Oh,
certificate of service at the end.
Now, there's another sworn inventory that follows that. That's
Right, and then we're gonna
2020.
move to that one next. Yes.
So what
All
is the
right.
question?
So we're asking the court to admit that notice of filing sworn inventory from 2018.
I object, Judge.
Grounds.
I object because I'm not sure this is the genuine document. I object because I don't see the reference, and I object because the counsel, both counsels, actually objected to my effort to introduce documents attached to my affidavit today as hearsay. So they are now trying to introduce the hearsay document using the same argument.
But the rules of evidence make this admissible because this is your statement that they are introducing. Not,
Well, I'm not sure that this is my evidence. So this is my document. May I ask the counsel, where did she get this document?
This is on file with the district clerk, Judge,
Where did you get this document?
from the clerk's office.
it appears
How-
genuine. Hey, hang on. It appears genuine on its face. So I'm going to admit it.
All right,
The
and ma'am,
2018 inventory.
okay, ma'am, were you
file
represented?
mark. Hey, when I talk, nobody else does.
Sorry, Judge, I couldn't hear it.
The petitioner's sworn inventory, file mark dated April 25, 2018, among the papers of this case, including its various attachments, is admitted as Reporter's Exhibit 1. Next.
Judge, we'd also move to admit petitioner's notice of filing sworn inventory. It was filed in this cause number on January 17, 2020. It is attached immediately following the document that was just introduced to the court reporter's supplemental motion. It is signed by Ms. Telegina, and the first notice she filed at pro se. The second page states petitioner's sworn inventory, and she has signed, and it is notarized. So that is the next part of the attachment. It starts on page 9 of 24, and it goes through page 15.
Objection, Judge.
I have it before me. What objections, Ms. Telegina?
I object to the document because the document is not full, it is redacted. And same objections to the previous document. As you can see, Judge, I now recall filing this document, but if you look, there is a stamp. I assume that the counsel answered my question that she got it from the court record. So I assume the counsel is telling the truth. So if this document was indeed got from the court record, then if you can see, there is a notice, then petitioner's sworn inventory, then there is a table with 1, 2, 3, 4 pages, and then there is a list of exhibits, exhibits 1, 2, 54. Where are these exhibits? I filed these exhibits. Where are they? Because these exhibits, Judge, in the inventory, there is a reference to these exhibits, and these exhibits are part of this inventory. Without these exhibits, this inventory is redacted, and that it is losing its actually its content, which is vital for this discussion.
I disagree.
Where are the exhibits?
I disagree. The exhibit is admitted. You're welcome to supplement with additional documentation if you wish.
I cannot supplement, Judge, because this is not my evidence, and I already raised my objection that this is heavily redacted documents, which is not full.
It is admitted.
Okay, ma'am, you got divorced in July of 2017. Is that correct? You had a settlement agreement, correct?
You asked two questions, ma'am.
Okay, did you reach a settlement agreement in July 2017 with your husband where he agreed to pay you that $100,000 up front and then $60,000 a year for 4 years?
We have different opinion in this litigation. What is this agreement? So
Okay.
I
He agreed to
disagree
pay
that
you
this
money.
is a settlement agreement.
Okay, but that's what it was called, right?
If you're referring to the title, then refer to the title, but I didn't, I disagree that I signed a full settlement agreement.
Okay, but you agree that was the title of that document, correct?
What title of this document?
The marital settlement agreement where he agreed to pay you $100,000 lump sum and then $60,000 a year for 4 years, correct?
Yes.
Okay, and then after that happened, you filed a sworn inventory, correct?
Which inventory you are referring to?
The first inventory in April 2018, you filed that in court, correct?
Yes, I think so.
Okay, and do you agree? You said to the court that you had almost $8,000 in a Chase joint checking account in 2018, correct? I'm looking at the first page of the inventory from 2018.
You are referring to Chase John checking account 2392?
Yes, 7,953, correct?
That's what it says. Move on.
Okay. Ma'am, you also had over
What says,
65
Judge, just a second, because it's not clear, what. You don't,
It's clear to me.
it's not clear to me. I'm the one who is asked the question. So
Oh, well,
the question was, if that was a balance in Chase joint checking account, yes, I think so.
Okay, and then you told the court you had a $60,000 Porsche car. What happened to that car?
I didn't have it, my husband did.
And then you told the court that you had a lot of other money and ownership interests and mileage in airlines and intellectual property rights in blogs and books. A lot of other assets are listed on here, correct?
Can we go one by one?
Do you recall filing this inventory?
Yes, I recall filing this inventory.
Okay, and do you see on the second page of it, it talks about your Russia country houses that were gifted to you by your parents, that you have 100% interest in one house and 50% in the other house?
What exactly line are you referring to?
4 lines from the bottom on the second page.
Yes, and I testified today regarding these houses.
Okay,
Yes.
and you see 2 lines above that, it says total community estate, $132,000, correct?
Just a second. First, let's first talk the property. I see.
No, that's not my
the-
question. My question is, does it say 2 lines above that, $132,000, 132 and what is that? $6, $8 for the total community estate? Is that what it says?
It says, but my husband controlled this.
Okay,
money.
and so, and every time you have testified or filed documents in this court, are you telling the truth?
Yes,
Have you ever lied to this court?
no,
Okay, we're moving on to the next inventory that's been admitted. Do you see on petitioner's sworn inventory that was filed in 2020? So we're looking at the third page, which is the actual first part of the chart.
which page?
The third page of the second inventory.
Yes,
So it has, it's a big chart. In the first chart and under description, it says undivided real property. Do you see that? On the left-hand side, it says as of 8/22/17.
ma'am, there is a number to each line. Can you refer to the number?
Line number 1, A1.
Not line, number of the line. Box are you referring to? You see, there is a line. Yeah, it will simplify. Page
Line
3.
1 says undivided real property.
I see it.
I failed to, Judge, help me to find it.
This is the top of page 2.
But I was referred to page 3 on the top.
Okay, well,
Undivided real property, yes.
yes, and on the right-hand side, right next to undivided real property, it says $2,452,248.77. Correct?
Yes, that's what it says.
And you're telling the court now you don't have access to any of that?
Yes, exactly.
And so where is all of that money and all of that real property?
My husband confiscated all this money.
Okay, and you don't have access or any rights to any of it? Is that what you're telling the
No,
court?
my husband confiscated all this money. That is this litigation of 5 years was about.
And do you
If you
see
look at this,
online
ma'am, just for you to
objection
understand-
non-responsive?
Okay.
Judge, one at a
Time
time.
out, time out. Next question.
Do you see on line 2, right below that, it says to Telegina, $1,961,799.01.
That was my proposition of to the court how this property should be divided. If you can,
Okay.
if you see, so that was my vision how this property should be divided. But my husband got all the property.
Okay, do you see on line 4, it says Telegina's Chase checking. On the left-hand side, it says net value 8,688.49. And then under to Telegina, it says $3,100.39.
Ma'am, if you see line table B, column B is net value of our, it was the date as of July 21st, 2017. Then column C is net value as of a year late, August 22nd.
Okay, and then let's skip down to
2017, right? So at the date, on August 22nd, the Russian consulate issued the divorce certificate.
okay,
And at
I'm not
that
asking you about
date,
that anymore.
at this account, at
Ms.
this account-
Telegina.
Objection, Your Honor,
Mi-
non-responsive.
Ms. Telegina,
Yes, sir. Yes, sir.
I want you to listen to the question and answer the question. And if you want to elaborate and explain what you think is unfavorable to you, you'll have an opportunity, but it's not now, unless it's implied by the question. All she asked you was what the paper says. That does not trigger a right for you to give an explanation. Now,
Donna, I just wanted to explain to you. that I
no,
was
no, no,
trying-
no.
Okay, okay,
I've heard enough.
let's try.
Next
Sure.
question,
All right.
Ms. Stolberg.
Ma'am, do you see on line 24, you told the court total cash net value $1,500,206.27, correct?
This is estimated value of marital property that my husband got, all of it.
Okay, and then there's other details of other information about savings plans, pension accounts, other property, other mileage programs, other furniture. There's a lot of other details in this document, correct?
Yes, there is a
And
lot
it-
of details.
It details a lot of other assets that you've had in the marriage, correct?
No, my husband had this property. So
Okay,
just a second. I listed in this inventory.
Did
The
you hear my
total-
instruction? Hello. Did you
Yes,
hear my
sir.
instruction to you? Follow my instruction.
I will try.
Answer the questions.
I will do my best, Judge.
I doubt it, but try.
all right, and then you see on line 95, it says monthly income of Telegina in 2017, January through August, $15,769.12. Correct?
I'm sorry.
What?
I'm sorry,
excuse me?
counsel. Where are you now?
Line 95.
Ma'am, it's
No,
not
this,
monthly
hang
income.
on, hang on.
No, the
This
answer
may
is
be
no.
simpler. This may be simpler, counsel. If you simply point out to me items that are in the exhibit. And then we'll give Ms. Telegina an opportunity to come back and undo the damage that she thinks may be done by that.
Okay, I would just
She
point
doesn't,
out,
you don't.
Yeah.
The paper says what the paper says.
right. I would just highlight, there is a monthly income section in the inventory where she's making at least $1,300 a month. In
No,
2016 and
ma'am, no.
2017.
No.
Hang on. All right, Ms. Telegina,
Yes.
My patience with you is wearing thin. You do not get to jump into the dialogue at any time you choose. There must be some orderliness to this procedure. Now, next question or presentation you want to make, counsel?
That's all the questions I have for today, Judge.
So I have a few. And then Ms. Telegina, I'll give you an opportunity to respond to other matters. First, as to the payments that you received in 2017, 2018, 2019, 2021, and 2022. Were those treated as income in any way so that taxes were paid out of those payments?
I report, my husband and myself, we both reported this as, my husband reported this as alimony. The money that he paid to me. IRS didn't accept this. They requested more information from both of us. They reviewed, so we presented the documents. They reviewed the agreement and came to the conclusion, and my lawyer, Mr. Dupre, testified about this at trial, so that this is not income.
All right, so
IRS disagreed to treat this money as income. So this money were reported to IRS. In each tax declaration that I filed, I attached this agreement. However, the IRS refused to treat this money as income of my
all right,
income.
so you did not pay income taxes on the $100,000?
No,
And what about the
it was
four
not my
other?
decision, Judge. It was the decision of IRS.
I'm not blaming you, ma'am.
You know, I'm just explaining that, yeah,
I'm not blaming you.
yes.
And as to the other four payments of $60,000, did you pay income taxes on any of those amounts?
No,
So I have to express some curiosity about where that $100,000 was, or where it shows up on your 2018 inventory.
$2018?
Yes, ma'am. That's Reporters Exhibit 1, filed April 25, 2018.
Okay, so Judge, if you look at, let's look all at this in inventory. As you can see, there are two columns, net value as the date 1 month before the certificate of divorce was issued by Russian consulate, and then second column, the date of when the certificate of divorce was issued. So this inventory is of certain date, because the judge told us to produce the inventory of certain dates. As of this date, I haven't received the first installment yet.
Okay, stop. You're referring to the 100,000?
Yes,
Well, does it appear on his part of the inventory?
he never produced an inventory. So once again, at the date of this inventory, which is August 22nd, 2017, I haven't received the first installment yet. However, if this money
Wait,
are
wait.
sitting,
Wait,
yes,
I am confused.
yes.
This inventory is dated April the 25th, 2018. Now, where do you get the date August 2017 from?
Judge, you know that before you took over this case, we had another judge. So the judge ordered us to produce inventory as of certain date, because her legal position was that we are already divorced on 22nd of August 2017, and that's why it's not my business to know how much money my husband had after that. So this inventory, the assets are listed to a certain date. Net value, column B. So I'm directing you to page 2 of the inventory. Column B, you see line 1, it is listed as of July 21st, 2017. That is 1 month before the certificate was issued. Then column C, as of 22nd of August 2017. This is the date when the certificate was issued. So judge wanted to know how much money we had 1 month before the divorce certificate was issued and as of the date when divorce certificate was issued. So according to my own assessment.
Okay, stop,
yes.
stop. We are not on the same page. I am looking at the document that is Reporter's Exhibit number 1. Your inventory dated April 25th, 2018.
No, judge, that it was like, look, let's read my petitioner sworn let's look the document. A fully complete list of all properties in my possession or subject to my control that I claim belong to the community estate, me and Vladimir Nichayuk, as of July 22, 17 and
Okay.
August 22, 17.
Hang on.
Read the document itself.
I'm trying to get there.
Judge, I think she's referring to the second inventory.
That's what I was afraid of.
The first one at the very top, it says inventory as of 4/23/18.
Then I'm confused. Which inventory we are discussing now? I'm sorry.
We're discussing
I was discussing the.
Quiet. We're discussing the 2018, as I've said repeatedly.
I'm sorry, Judge. I was looking to the second one. I'm happy to answer your questions. Apologize for this. Yes.
The question is, where does the $100,000 appear on that inventory? And you've told me that you had not yet collected it. But it's now already April 2018.
But Judge, here you can see online now I got you. This is inventory as of April 23, 2018. First line is joint checking account. There is $7,953. Then her Chase checking account, my checking account, $16. Then her Wells Fargo checking account, again, my checking account, $2,000. Then you can see $65,000, $276, her brokerage account at Wells Fargo. So that's where I paid during the first year of litigation. I had a lawyer who charged me approximately $80,000. So at this point of time, I was represented by a lawyer, actually by Mr. Dupre and Mr. Porter. So by April 23, 2018, from $100,000 that I got from my husband, there were whatever is listed here were left. So $7,953, on our joint account, $16 on my Chase checking account, $2 on my checking account in Wells Fargo, and then $65,000, $276 at my brokerage account. $43.
Okay, then. Very well. What did you do with the $100,000 initially? Where did you deposit it?
I deposit them to Wells. I think no, it was not I deposited. My husband transferred it to my account at Chase Bank, and so it was. So you see here, and I transferred that. I tried to make some investment, and I was of course paying. So here you can see that as of April 2018. This is second year of our litigation. I have approximately $65,000 plus $8,000. That's what I have left from 100,000 minus legal expenses. Yes.
Okay, I got it.
Yes.
Let's stop there. And the springboard from that fact is, what became of that $65,000?
Say it again.
What became of the $65,000?
What do you mean what became?
Where did it go?
Oh, I spent them on my legal bills, and I spent them on my monthly expenses. My Mr. Porter, to the best of my recollection, for his services, and he represented me for the first year of my litigation for 10 months. He charged me approximately $80,000. And these are only his fees without, I think, expenses, court expenses. And also I was paying to Mr. Dupre, who was representing me in our discussion with, for example, tax authorities, because we had this discussion with tax authorities regarding this agreement, marital settlement agreement, if this is an income, if this is an alimony, what is this money? Should I report them as income? And so after I filed this petition for divorce in November 2017. I received money from him somewhere in August 2017. I filed for divorce in November. From November till September next year, Mr. Porter was representing me. So a major portion of $100,000, which is actually nearly $100,000, I paid for his legal fees. So I would rough estimation that I paid nearly all $100,000 went to legal bills. Nearly all of them for the first year of this litigation. And then I started to represent myself. Because I couldn't afford a lawyer, because I lost my job. I was receiving approximately $700 a month from a remote job in Greece. But this job stopped in January 2018. So as of January 18, I don't have any job or any other income.
So you weren't paying any legal bills in 2022? Or were you?
In 2020, what year?
Last year?
No, I was paying some legal bills to Mr. Dupre, but not that much. And I was paying court cost because Mr. Dupre was not representing me in this litigation, but he consulted me from time to time on some, but that was like, Judge, that was altogether, I don't know, it was not more than $2,000. So the major legal bills I suffered from were 2017 and until October 2018, for 1 year of this litigation.
So in 2019, you received $60,000. 2021, you received $60,000. 2022, you received $60,000. This all after you had substantial legal bills to pay. So where
Yes,
did
I
that,
agree, Judge.
where did that money go?
Okay, today let's do a simple math. Let's try $60,000. Let's divide to 12 months.
It's $5,000 a month.
Okay, today I testified, Judge, that my monthly expenses are around $4,000. And on top of that, I was paying legal bills in Russia. So if you ask me where this money went from, like I spent a significant amount of money on court reporter cost, because we had this is a litigation of 18, 19, 20, 21, 22, 23, or 5 years. My husband spent, if you recall, $800,000. So I spent only $80,000. So this money went to my monthly expenses here, because, like, for example, now, as of next month, I will be, thanks to American government, I will be paying $1.80 for my insurance, but I was paying, my monthly insurance was nearly $700, because I'm 55 years old woman with a lot of troubles with my health. So
I understand.
So the answer to a question is legal bills in Russia and monthly expenses here.
Yes, I understand the answer, including court reporter fees and
Yes.
the expenses of living, all
Yes.
to be carved out of $60,000 over the course of a year.
Exactly. That would, and also during last year, Judge, I think
Please. I have another question.
Yes.
On your current affidavit that relates to your indigency,
Yes.
you describe having, well, you did have some $4,000 in cash. I believe it's down to $1,000 in cash.
Yes.
Do you mean to say by that is actually in currency?
I don't
Dollar bills?
Yes, it's just like, cash.
It prompts the question, why would you maintain $4,000 in cash money about your person or in your habitation, as opposed to putting it in a bank?
I had money in the bank, Judge. So it was like, I had money in the bank all this time. I was even making some investments, and but when I lost this litigation, and when I realized that I need to have some money to find urgently some money because I have very few money, very few money left. And after so I was planning to go and see my family and my friends in Greece. So I was hoping to get some money there or a job there.
Wait,
So
it's
I took from the bank.
hang on.
Yes.
You are straying afield. My question was, why do you have this amount of currency, cash money, outside of a bank?
Because I was planning a trip to Greece or to Russia. And because of the Russia is under sanctions now, American cards are not working there, they're blocked there. So I took some cash from the bank in thinking that I need to go there, because there at least I have some friends who will be able to help me. Here I have no one who would be able to help me. And with this, when I realized that actually no one will be able to help me there, because people are running from Russia now, like nearly all my friends there now left Russia. So I canceled my trip. I also realized that I cannot afford this trip, because it's not only about cost of the tickets, but going there, I still would need to bear all the expenses that I am committed to here. Like, for example, the rent contract. It's more expensive to get out from the rent contract than to keep it. Judge, if you ask me a question, what I'm going to do next month, I don't know. I don't know. I'm in default in all credit cards but one.
Stop, please. Have you sought employment in a way that could employ the use of the Russian language, such as a teacher or as an assistant at the embassy or in some other way?
Judge, in each and every my application, I listed the language that I speak. I tried to get the job in Macy's. I tried to get as someone who sells clothes. I can now got in my someone who sell clothes. So because I don't have that experience. So that is probably the reason why my application were denied. And if you let me to go through my email.
Please stop. I asked you about utilizing your English language, such as a teacher or at the embassy. And now you've begun to tell me about jobs as a sales lady in a clothing store.
The embassy, Judge, the embassy, Russian embassy is downsizing. They closed, they're cutting their staff because of the because of the disastrous relationship between Russia and US. They're cutting diplomatic staff. They're cutting, they're closing consulates. Actually, I think there are only 2 consulars offices that are left. There were 6 of them. So we have one in Houston, but so they're not hiring. Let me put it this way. And to be a teacher in US, I think who will hire me, Judge? I tried to apply to one. I filed 150 application. If you give me 30 minutes of your time, because all the denials, it comes via email. If you give me 30 minutes of your time, I will take you through each and every denial I received within the last 5 months and tell you what job I applied, when they denied my application. I applied first as
I'm sorry. I need to try to get this job application issue in some context. I got the impression that all of your job applications and denials were occurring from October of 2022 and beyond.
Are actually no, Judge. If we have, first of all, from September, you issued your order on August 23. I was working hard because, you know, I filed 300 pages motion for a new trial, which you denied, but it took a lot of efforts. But meanwhile, I was applying nearly every day. I started actively looking for the job as soon as you issued your order of 23rd of August 2022. So I was actively looking for a job in September, October, November, December. I keep looking now. However, even during these years of this trial, I was not sitting and not looking for a job. And in my, to the best of my recollection, I filed at least, I think it was at least 50 documents showing to the court that I was looking for the job. And if now you will give me, if we have a break of like 5 minutes, I will probably be able to find this document because it was my production. I will go through these documents and I will show you that even working hard on representing myself on this litigation, I was still looking for the job. The problem is my age, the problem is my health, the problem is that I have no experience here in US. I have never been hired by anyone here in US. So even when I apply—
Excuse me, I have
Yeah.
one more question for you, I think, and then we will take a short break and I'll come back to other questions from council. The document that you attached to your claim of indigency, the one that's in evidence that says statement of inability to afford payment of court costs or an appeal bond. Where did you get that document from?
I downloaded it from the Supreme Court side. It's, I think, yes.
Did you
Was
make
it
any
from the Court of Appeal, Judge? It's a form that is, I will probably give you, will be able to, this is the form that, to my best understanding, is approved by the Supreme Court of Texas.
The question I asked you was, where did you get it from?
I downloaded from the court side. I think it was
Which court?
one of the Texas appeal court.
Very well. Did you make any modifications to it before you began to fill it out?
No, I made modification during when I was filling it out, nothing else. Like, I can give you an example, Judge. What modifications I made. Now, so are you represented by legal aid? Question number 2. If you can see, so I removed the option here, which is now, so it answers my situation. It shows my situation. I asked a legal aid provider to represent me, but the provider couldn't take, so I removed what is not applicable. That's one change I made. That is all, Judge, nothing else.
All right, I know everyone is fatigued at this point, so we're going to take a short break. And when we return, Ms. Peoples, you can have the witness, and then Ms. Stallberg. I'll call this 5 minutes worth to try to speed things along. 5-minute recess. All right, Ms. Peoples, you could unmute when you're ready.
Thank you, Judge. Ms. Telegina, yes or no, are you aware that there are jobs listed as we sit here today for Russian translators through Indeed.com?
Yes,
Are you aware that there are jobs listed as we sit here today for Russian translators on simplyhired.com?
no,
Have you looked at simplyhired.com
no,
for translation jobs?
no,
Are you aware that as we sit here today, there are jobs listed on ZipRecruiter for Russian translators being advertised?
I looked through ZipRecruiter, but not for these particular jobs.
Would you agree that your particular skill set of being fluent in Russian as well as English language would make you an ideal candidate for jobs listed on websites such as Indeed, Simply Hired, and ZipRecruiter for gainful employment as we sit here today?
Ma'am, I don't have a certification of to be a translator.
Objection, Your Honor,
certification is required.
non-responsive.
No, I don't think that I'm qualified.
Next,
Okay, pass the witness, Judge.
Ms. Stahlberg.
Yes, ma'am. You testified your last job was a remote job that you had in Greece.
Yes, ma'am.
Okay, have you applied for any other jobs in Greece recently?
No, because I couldn't travel to Greece.
Okay. Did you travel to Greece for your last job?
No, it was a remote job.
Okay,
And I
did you
lost
look,
it in 2018. There is a
Did-
war in Europe, ma'am.
did you
there are
look
no
for any
jobs.
other? Sorry, did you look for any other jobs in Greece that were remote?
No, no, because I don't have permit for living.
Objection,
in Greece.
non-responsive. After no.
Overruled. Next question.
Have you looked for any remote jobs here in the United States?
Yes,
Do you have a work permit or the legal right to work here in the United States?
yes,
Have you ever been to anywhere locally that you saw a now hiring sign?
yes,
Did you apply there
Yes.
for a job?
yes.
Has that happened every single time you've seen a now hiring sign?
I don't leave home very often because of my health condition, but I specifically went to Woodlands Mall, for example, and entered each and every shop which had that sign, including Macy's.
Okay.
And I
Have you-
applied.
Okay, have you applied other jobs that had now hiring signs outside the mall?
Yes, I entered several restaurants near the place I live, but because I don't have a car, it limits my ability to travel. So I was looking for the job walking distance from my place.
Okay, did you look for, but you're also applying to entry-level jobs, is that correct?
Yes, ma'am.
And
I
have you
tested-
applied online at entry-level jobs for remote working from home jobs?
Yes. The denial of my last application I received yesterday for the assistant job.
Okay, but are you
Executive assistant
applying,
job. It was a remote job.
are you applying for other lower jobs like a greeter at Walmart or anything you can find?
I tried to apply at Walmart. My application, for whatever reason, they were not be able to process my application. So, ma'am, I tried and I keep trying.
Okay, did you follow up with anyone about that?
Say it again.
Did you call them and ask them why not? Or
I
talk to anyone?
No, I didn't call. I filed when something is wrong, when you're trying to process the application, there is an option there to report this issue to the how they call it, to their support. So that's what I did.
And that's all you did?
Yes, that's what I did because I was preparing for this hearing, so. yes.
Okay, I
I
passed.
was
on.
not, yeah. Judge, can I call myself now as a rebuttal witness?
Well, you still are the witness, so you will have an opportunity to give more testimony. But Ms. Peoples, do you have anything else?
I do not, Judge.
I guess I just have one. Or two more questions. Have you contacted the Russian language program at the University of Houston to see if there is an employment opportunity there using your skills?
Judge, I researched. I was thinking in this direction. So I researched the website of several universities. I think it was University of Houston, one of these, but there were no opening where they are, where I could apply for to file application for a job. At the time I researched, and then I focused on more simple opportunities. I was researching LinkedIn. I was researching two sites that the council was referring to. I think it was, let me open them. It was ZipRecruiter or Indeed. Right now, I sent my resume to several headhunting agencies that are when the company don't hire directly, they hire through providers like through a third party, and normally they would offer a job that doesn't require even a university degree. So it's kind of legal assistant job, executive assistant job or something like this.
So I gather you never physically presented yourself to a place like the University of Houston Russian language program to make an inquiry in person?
Your Honor, I don't have a car and I don't have money to travel. For me, the only opportunity to travel is to hire Uber, which is expensive. So I was looking for a job which is either pay for relocation. There are such opportunities as well. So I was actually looking for a job across US as the company is willing to pay for my relocation because I don't have money to pay for my own relocation. I was looking for remote jobs, all kinds of remote jobs across US. And I was looking for a job which is walking distance, like, for example, 5 miles from me. Because, I mean, I'm in this situation when I cannot afford the car, and with my credit score, which I would probably not be able to get any credit in the nearest 5 years. But that's so I was looking for a job that doesn't assume me driving somewhere, because it's nearly impossible for me.
What is the rest of the testimony you wanted to offer?
Judge
I would
Delaney,
like, you introduced into evidence, Your Honor.
I'm sorry,
the-
just a moment.
I apologize. Ms. Peoples' computer just crashed. She is in the office with me, and so she's going to get on my computer. We'll be on the computer together.
All right.
Your Honor, I would like to go through the inventory that you admitted into evidence.
Here.
Because I think it was a lot of confusion around this inventory, and I need to explain to the court and clarify all this confusion and to counsels as well.
So
So,
direct us to the inventory that you're about to speak of.
yeah, I'm directing you to inventory which was filed on January 17th, 2020.
That would be Reporters Exhibit 2 on this record.
So 3 years from now. So first of all, I would like to testify that this all the data, all the numbers in this inventory, they as of 2017, despite the fact that the inventory itself was filed in 2020, all the numbers are, and Judge, can you please look into this inventory so we would discuss it?
Yes, just a moment.
Yes.
I have it.
So the page the first page is notice, my notice of filing sworn inventory. And then my statement are, I direct you to paragraph 1, which states, a full and complete list of all properties in my possession or subject to my control that I claim belong to the community estate of me and Vladimir Nechayuk as of July 22nd, 2017, and as
Judge, I'm gonna have to
July-
object to reading from the document. It speaks for itself.
Overrule.
So this document is not as of 2020. This document provide information as the judge requested us to provide as of the date when the certificate of divorce was issued, which was August 22nd, and the months before. Now, if you look at the table, and there are several columns to this table, column A, column B, column C. Column B is all the numbers are as of July 21st, 2017. 1 month before the certificate of divorce was issued in Russian consulate. Column C, all numbers are as of August 22nd. That is the date when this certificate of divorce was issued by Russian consulate. Then in column E and F, you see the number $2,452,248.77. That was my estimation of our marital estate. And 90% of this estate, according to my estimation, was controlled by my husband, which actually you can see from all below lines. For example, on my checking account, there were like, on the date when the divorce certificate was issued, line number 4, there were $3,875.49. Then there was another account, line 8, where I had $10,012. Then another account where I had $2.67. Then I have $786 dollars and 20 cents in my account in Greece. That was my monthly salary at that time. Then it comes line number 12. It was $44,881.40. It was joint account, and my husband transferred this money to his own account. So at certain point, then you can see 1 million, line 13. It is my husband account, checking account. Then you see $394,785. It is again my husband account. Then you see line 18, $10,099, $993.65. Again, it's in my husband account. Then so all other lines, these are money that were controlled by my husband. So line 25, that my opponents, they, for whatever reason, they believe that that was my monthly income. Line 29 says that as of the date when Russian consulate issued certificate of divorce, I controlled $14,676.97, while my husband had on his cash account, saving and checking, $1,510,313.55. So I had roughly $14,000, and he had $1.5 million on his checking account. Then we goes to his ExxonMobil saving plan, line 29, 30, 31, 32. He totally controls $237,078.23. Then we goes to his pension and retirement account, line 35 and 36. Line 35, it's $370,777 on his ExxonMobil pension plan. Then we so these tremendous numbers, and then there is a Porsche Macan with a purchase retail price value $64,198. He took the car, and I have never seen the car after the date of our separation. So now, I'm now saying that all these millions of dollars, they were not controlled by me. At the date as of our divorce, I had on my cash, on all my checking and savings account, roughly $14,000. Now, lines regarding the community estate, the property. Okay, now, Judge, I direct you to line 87, because my opponents referred to this line. Telegina separate property, 100% shares in Russian LLC Grupa Компаний Vkus. The company was bankrupt. I paid for its liquidation procedure. And so it's not only I didn't receive anything from this company, but it was bankrupt. And I attached to this, you see, why I was insisting that this document should not be admitted, because this document have exhibits, a lot of exhibits. For example, There is exhibit 4749 that shows the liquidation of this property, the bankruptcy. And we don't have this exhibit in front of us. Then regarding two properties in Moscow region, line 88 and 89. It is stated in last column, the property is abandoned for 25 years, negligible value. Second property, it is stated here in my sworn affidavit, and I testified the same today, that the property is abandoned for 15 years, negligible value. Judge, I would like to bring to your attention and to the attention of counsels that I testify, I made this sworn testimony 3 years from now. So if I was lying, my husband had 3 years and he has lawyers in Russia to prove that I'm lying. So he had 3 years to find, because he is located in Russia, physically located in Russia.
Judge, I'm gonna have to object to relevance of this line at this point.
I guess I don't understand the relevance either, so I'm going to sustain. Let me interrupt to ask you this question, please.
Yes. Judge, this is coming to my monthly income. This is important.
That's the
Because-
question. That's the question I was going to ask you.
Yes,
Explain the monthly income shown on 95 and 96.
Judge, do you see /12? It means in 12 months. So divided by 12. It's like monthly income of Telegina in 2016, according to my tax declaration, which is exhibit 28, which is not here because my opponents failed to produce this exhibit. My monthly, my income in 2016 total was $15,885 divided by 12.
Okay, so here's my question. Did you not testify earlier that you've not worked since you've been in the United States?
I testified, Judge, that I have never been employed here in the United States. I testified that my employment with Greek company stopped in January 2018.
Okay.
So
Well,
I
got it. Now, I want to go back to the top of your exhibit or their exhibit, this same 2020 inventory. At the beginning of the tables, we have item 1, undivided real property, $2.4 million. Does that refer to land or buildings?
no.
What is it?
It's the money that we all, both of us, we had documents to prove. This money is either cash, either savings accounts, either pension accounts, and attached to this inventory, as you can see on page 7, there are 54 exhibits justifying each and every number. And unfortunately, my opponents produced this inventory without these exhibits, because each and every number is justified by a document.
So when the inventory uses the word real property, is not referring to real property.
It's real estate, Judge, probably. Marital estate, probably. I don't know how it's as of the date when the divorce certificate was issued. So it's cash. So there are it's bank and line 3. It's bank account and brokerage accounts with financial institutions. Then the list. Then saving plan accounts, line 29, and all numbers listed below. Then pension and retirement account, all listed below. Then vehicles listed below, other property. So then some mileage, but then liabilities. But I'm directing you now to line, probably to understand the whole thing. I'm directing you now to line 83 and line 84. So as of the date of when divorce certificate was issued, my husband controlled $438,577.91. And I control $13,670.86. As of the date when the divorce certificate was issued here in Houston, because again, and each and every number in this inventory is supported by documents attached to this inventory. And the list of these exhibits, 54 exhibits, it's on page 5 and 6. And we don't have them now. Theoretically, I can dig into my archive into my files and find these documents.
Objection relevance.
Properly.
Judge.
I sustain.
So historically, Judge, what happened? At the date when divorce was issued, I had approximately $13,000 roughly on my account. My husband had nearly $2.5 million. He paid me first installment of $100,000, which I nearly all gave to spend on legal bills and on my my everyday bills.
Judge, I have to object cumulative at this point.
I sustain. Ms.
heard
Telegina, I have a question for you.
Yes.
Look at line 4 of the 2020 inventory.
Judge, it's not, I would like to object. It's not 2020 inventory. It's
Okay, I get it. It's as of
yes,
sometime in 2017.
as of the date when the divorce certificate was issued.
Yes. So you say. So on line 4, you list something described as Telegina's Chase checking account with
Yes.
$3,875 in it.
Mm-hmm.
Then on line 8, you list Telegina's SureBank, SBER BANK checking account, Spurbank.
Sberbank, yes. It's
With
Russian bank. Yes, Judge.
with $10,012 in it.
Yes.
Line 10 has Telegina's Piraeus, PIRAEUS bank with $786 in it.
Yes, Judge. That's all I had at that time. But there were also liabilities, Judge. So the like credit card payments, right? So there is a sum of line 4, 5, 6, 7, 8, 9, 10, 11. That's what I had at the date when the divorce certificate was issued. Then minus liabilities I have at this date, and then we end up with the number of $13,670.86 that I had at the date on 22nd of August, 2017.
Okay, I've heard enough for now. Are there some more questions, at least from your side? Ms. Peoples and Ms. Stahlberg, do you have any questions?
No questions, Your Honor.
No questions. I just wanted to call Ms. Hernandez briefly for the record. If you think it's necessary.
Well, it's still Ms. Telegina's side of the case. Do you have other evidence to present, Ms. Telegina?
No, Judge, I think I testified to each and every line of my affidavit. I hope I was able to clear the confusion about this inventory of 2017. All these huge numbers are I just want to be crystal clear that my monthly income was not 15,000, but line 96. It is what was reported in tax declaration as my here in US. Exhibit 28, I assume this is tax declaration, or I think Exhibit 28. Of course, yes. Exhibit 28, it's our joint 2016 tax declaration. So here in US in 2016, I reported in our joint declaration, my total income of $15,885, which is, if we divide by 12, we come to, again, line 96, we come to, this is column ABC, column C, we come to $1,323.75.
All right,
From remote job in Greece, Judge,
very well. Go ahead, Ms.
which stopped
Stahlberg.
in January 2018.
So I'll swear your witness. Do you swear the testimony you'll give in this matter before the court will be the whole truth, so help you God?
Yes.
Very well.
All right, please state your name.
Haley Hernandez?
And you're employed as the court reporter for County Court at Law number 3, is that correct?
Yes.
And in that capacity, were you the court reporter on the divorce in this case, the jury trial?
The jury trial in August of 2022, not the divorce jury trial.
Okay, so how long did the jury trial in 2022 last?
5 days.
Okay, and that's the case that's currently Ms. Telegina is appealing, correct?
Yes.
And that's the case that we're talking about, the court reporter's record and whether or not she is unable to afford payment, correct?
Yes.
Have you calculated the amount that it would cost to prepare the court reporter's record
Yes.
for the appeal? And are you familiar with the appellate record and all of the rules of the Court of Appeals?
Yes.
And how much does it originally, how much is the original cost of that record?
The original cost of the record is $8,818.50.
Okay, and that includes exhibits, correct?
Yes.
Okay, and that is essentially $6 per page, in addition to a cost for exhibits, correct?
Yes.
Okay, and when you were looking at the case, you sometimes work with people to provide the reporter's record at a reduced cost, is that correct?
Yes.
And so sometimes you charge at as much reduced cost as $4 a page, correct?
Yes.
And then you charge 50 cents per exhibit, correct?
Yes.
Okay, and what is the total if you were to charge a reduced cost?
$6,374.50.
Okay, but you're asking the court to order the reporter's record produced at the full cost of $8,818.50, is that correct?
Yes.
Okay, and that is a reasonable amount, the reasonable and customary amount that you charge for parties to prepare the court reporter's record for appellate cases like this, correct?
Yes.
And how long have you been a court reporter?
Almost 7 years?
Okay, and that's how you're employed full-time, correct?
Yes.
I pass the witness.
So, Ms. Telegina, do you have questions?
Judge, I maybe have, but I'm exhausted, so I pass the witness. I simply don't have the energy to ask questions.
Ms. Peoples?
No questions, Your Honor.
Anything further from the reporter?
That's all we have, Judge.
So from the respondent side, any evidence?
No, Your Honor, we stand on our written response to the court and our objection to Ms. Telegina's affidavit, and pointed out that we believe she has not provided sufficient evidence to support her request and to prove her inability to get a free record in this case or have any discount of the costs, and just ask the court to consider our written response in this matter.
So, Ms. Telegina, do you have any argument you want to make at this point?
Yes, I do, Judge.
Very well. Go ahead.
Give me just 1 second to pull the document. Because I want to. Judge, I actually, probably it would help if you now hear the motion for a free record that I filed on January 5.
I'm sorry. Are you asking me to do something?
I'm asking you to take judicial notice of the petitioner's motion for free court record that I filed on January 5.
I'll take notice that you filed the document, but not any specific details contained within it.
Because in this motion, I actually referring to several cases. Let me. Because among other things, Judge, since you decided to proceed with this hearing today, among other things, my job is today to convince you that my appeal is not frivolous. Would you like to hear my arguments, brief arguments regarding this matter, or you agree that my appeal is not frivolous?
I'll listen to your position.
Okay. In my notice of appeal that I filed on November 21, I stated that I intend to appeal all portions of the judgment, and 6, I quote now, that I intend to appeal all portions of the judgment, and 6, to alter the trial court orders, August 23, 2020, final order, and several interlocutory orders, September 12, 2018, that enforced Russian divorce issued here in Houston, December 12, 2018, on partial summary judgment, that was before you, Judge, and then 2 your orders of March 5, 2021 on Vladimir Nichayuk motion to dismiss, and March 5, 2021 on Vladimir Nichayuk's motion for summary judgment. It is well established, Judge, that absent trial court severance order, and there were no severance order in this litigation, all interlocutory orders, including partial summary judgment orders and or special exception orders and or dismissal orders and or sanction orders, are not appealable until final order is judgment. And in my motion, I rely on several cases are supporting my legal position. I therefore was not able to appeal any of these orders. First, I was not able to further in my motion for rehearing, reconsideration, and new trial that I filed on September 22, 2020, September 22nd, 2022, I alleged 101 trial court errors, including following errors that were directly related to my 7 appealable orders. For example, order of September 12, 2018, which enforced Russian divorce that was issued in Houston here. I alleged errors 79 from 79 to 91. With regards to the order on partial summary judgment that was issued by the court in December 12, 2018, I alleged error from 72 to 78. With regards to order of March 5, 2021, on partial summary judgment, I alleged error 6 to 31, through 31. On March 5 order of 2021, dismissing all my claims, I alleged errors from 58 through 69. And finally, on August 23, 2002 order, which is final trial court order on respondent claims on the attorney fees and cost, I alleged error from 79 through 91. Additionally, I intend to appeal to court orders sustaining respondents' defective special exceptions and forcing petitioner to drop our viable claims, including claim for divorce or claim for our infliction of emotional distress. or
Okay,
bodily injury
Ms.
claim.
Telegina,
Yes,
I believe you have established that there are arguably substantial claims or a substantial question for appellate review, arguably.
Judge, thank you. And 2 more points with regards to case law.
I
that,
don't want to hear any more case law. If you
Judge,
want,
please
if
give
you
me
want to,
three minutes.
if you want to submit case law to me, you may do it in writing. Here's what is going to happen. I have to take this under advisement. I'm not going to be able to give it my attention until this weekend, probably. I have to get up early tomorrow morning to drive to Huntsville to start an evidentiary hearing that's going to go on for a couple of weeks. I'm going to have to ask any interested party here, either respondent or the reporter, who urges me to find against the petitioner here to submit to me a proposed order with the necessary findings in Rule 145. In section F2, which reads, an order requiring the declarant to pay costs must be supported by detailed findings that the declarant can afford to pay costs. You might want to serve up as an alternative an order that the declarant pay the part of the cost that it appears that she can afford including installments. And finally, you need to include the language in paragraph 4, putting the declarant on notice about their appellate rights. Now, I'm not sure which way this is going to go. We're aware that only the declarant here, Ms. Telegina, can challenge my order. So for information here, Ms. Telegina, do you, I can't recall. Are you thinking that you will be challenging some ruling made during the jury selection portion of the jury trial?
Yes, Judge. And that's why I specifically requested the portion that whatever happened in chambers when we were when we were interviewing jurors. Yes, jury selection. Attached to my motion, actually, there is a list of errors of one very detailed list of 100 errors. So we can go there if you have energy.
Well, if I'm going to tax this court reporter with producing a reporter's record for the jury trial, I don't want to require her to transcribe irrelevant parts of jury selection that have no bearing at all on the appeal. So
I understand, Judge. The
counsel can pay some attention to that as best you can, giving some attention to Ms. Telegina's claimed errors. I don't recall off the top of my head any objection to any peremptory challenge, no objection to the granting of a challenge for cause. It's possible that they were there and I just can't remember them, but I'm sure counsel's notes will reflect that.
Judge, I can give you one example. Just one example.
The dialogue that occurred in chambers seems to be a matter that she would want to have transcribed, and I wouldn't oppose that.
Judge, not only, there was, if you recall, there was one lady who was a colleague of my husband from ExxonMobil, and whom I known personally. And then I looked through my files and I discovered that we were indeed
okay, don't spare me that information.
Yes.
Spare me that information, which I think is probably outside the record. But I do recall that you had some complaint about her being seated as a juror, and we interviewed her at some length, and I overruled your motion to exclude her for cause. So that might be a particular ground. All right. So Miss Mendoza, the bad news for you, I'm afraid, is that the transcription of this particular hearing is at no cost to the declarant. And should the ruling go against her, we're going to have to transcribe you're going to have to transcribe this hearing for the Court of Appeals to review it, if the ruling goes that way. So we're going to move as expeditiously as we can to get a ruling.
You now have a question, the last question for today. May I?
Try me.
When the Supreme Court issued this rule 145, there is a comment to this rule, one paragraph. Would you like to have my like 2-3 page briefing with cases regarding this specific paragraph? And the paragraph states
I will allow you 3 pages only.
on only this specific matter.
Yeah.
Okay, just to clarify the matter.
And 5 pages in total.
Briefing. Okay. Legal briefing with cases. Okay, Judge.
Okay.
The deadline?
Oh, how long would you like?
I want to expedite this matter as soon as, also I think there are deadlines imposed by,
Can you produce it by the end of Friday of this week?
yes,
That's the deadline.
I shall do that.
Very well. Okay, we're at an end tonight unless there's anything else from someone. Oh, one other thing. For Ms. Hernandez, in your initial contest, you made reference to ordering the county to pay for the transcription in the alternative. And I'm afraid the statute you cited to me applies in suits affecting parent-child relationship only, as I read it.
I think she's looked at that since then, I think, Judge, but thank you for clarity.
Anything else, everyone?
Yes, Your Honor. If either party, Ms. Hernandez or respondent, feels that there is a reply or response necessary to what Ms. Telegina files, will we be permitted to do so, and in what time frame and what page limitation?
How about 5 page by Wednesday of the following week?
Thank you, Your Honor.
And Judge, as far as the proposed order, could we have until Wednesday also for that?
That will be fine by me. Ms. Telegina, you're welcome to submit a proposed order as well by Friday of this week.
With findings?
If the rule requires it, I can't remember that it does.
It requires.
Well,
It
then they have,
requires the finding.
I believe the only thing that requires findings is an order denying you the free record.
Oh, number 2, finding required. Yes, you're right, Judge. An order requiring the declarant to pay cost must be supported by detailed finding that she declarant can afford to pay cost. Okay, you're right. My order will not have findings.
Yeah, if there's nothing else, I'll close the hearing.
Thank you, Judge, for your time
And thank
and
Ms.
for your
Wo-
patience.
Ms. Womack and Ms. Mendoza, thank you.